All right, everybody. Wanted to go ahead and tap into repossessions and charge offs. These are very similar in the process of repairing your consumer reports. The IRS protects us. So, as long as federal statutes, a lot of things you're going to hear me say are all backed and supported by the government. Like a lot of the things that I've seen in some of the other courses that I've purchased, they don't. They don't mention any of that stuff. They just kind of talk about, oh, send this letter here, but they don't explain anything to you, right? This is what I sent in and got mine removed, which may have been like 4 or 5 years ago, right? Some old stuff, right? So everything I'm showing you guys, you can fact check, you can pull it up on these websites. This is on the IRS's website. I'm gonna show you this little screen snippet here, then we're gonna go over to it right away. But if you ever want to find out what they do with canceled debts, foreclosures, repossessions, and abandonments, and how that stuff's supposed to be reported to the IRS. This is how you get these companies in trouble with the IRS, right? Because there are certain things they're supposed to send you, the consumer, or your clients, whoever, when they do this stuff and they don't do it, and they don't do it because you have to request it. If you have to request it, then that means they didn't do it, right? So let's hop on over to the actual website. Right, so here we are on the actual website, right? Very simple link. It's right here. Okay. This shows you what canceled debts, foreclosure, possession, abandonments are supposed to be, or how they're supposed to be handled, right? And everything is in chapter 1, right? You see right here, such as foreclosure, possessions, abandonments, all that stuff. It's all in chapter 1. So we don't even need to get through all this stuff unless we want to get to chapter 2 down here. You can read this stuff for that. But just for the sake of this argument, we're going to stick with chapter 1 and the canceled debts, right? Now, this is how you get these companies in trouble, okay? You want to reference these documents in your dispute letters. You want to be very technical, and you want to make sure you write it legibly as well. So in this situation, all right, here's how we can use this. It states here, generally, if a debt for which you are personally liable is forgiven or discharged for less than the full amount owed, the debt is considered canceled in whatever amount it remains unpaid. Now, if we just stop right there, this is the definition according to the IRS. Sounds a lot like a collection company, right? Sounds an awful lot like a collection company, because if Santander USA sells my repossession auto loan to Midland Financial for a cheaper amount than I paid for it, y'all can hear my dog, then that right here already tells us there's a definition and a procedure that should be followed by the IRS. All right. There are exceptions to this rule discussed in the exceptions later. Generally, you must include the canceled debt in your income. However, you may be able to exclude the canceled debt. Exclusions, right? Got examples for us here. John owed $1,000 to Mary. Mary agreed to accept, and John paid $400 to satisfy the entire debt. John has canceled $600 of debt, right? Now, explain this to me, if you can. How is it possible that income for a company is being written on your consumer report? Right? Can you explain that? It's income according to the company when they sell it. So why are they reporting income on your consumer profile as if you still owe them money? Right? You got to think about it for a second. These companies, say you owe them $10,000, they then sell it for $4,000, right? So if they sold it for $4,000, they made money. Now, why is it still showing up on your report that you still owe $10,000, or in this case, $6,000? It shouldn't be, because that's considered income, right? It should not be income on your consumer reports. Example, Margaret owed $1,000 to Henry. Henry and Margaret agreed that Margaret would provide Henry with services in full satisfaction of the debt. Margaret doesn't have canceled debt. Instead, she has income from services, right? So these are just examples, all right? Let's go to 1099-C. This is what's really important right here. This 1099-C form. If you receive a 1099-C form, that means an applicable entity has reported an identifiable event to the IRS regarding a debt you owe. For information on reasons on applicability on applicable entity files, form 1099-C, yeah. Unless you meet one of the exceptions or exclusions discussed later, this canceled debt is ordinary income. It must be reported in appropriate form addressed above. So why is these companies reporting income on your profiles? They can't. There should not be income being reported on your profiles, right? If you had a student loan that was discharged after December 31st, 2020, and the amount of discharge loan is non-taxable, you won't receive a Form 1099-C form from the lender or servicer of your student loan, right? And this just gives you examples of who needs to send you a 1099-C form: financial institution, credit union, right? All these people, right? Reason the credit failed this form, bankruptcy, right? Statute of limitations, expiration of deficiency period. These are all reasons that they could be filing it, but they still need to send you a 1099-C form. All right. Student loans. If you're responsible for making student loan payments, the loan is canceled or repaid by someone else, you must include the amount that was canceled or paid on your behalf in your gross income for tax purposes. However, in certain circumstances, you may be able to exclude amounts from gross income as a result of cancellation or repayment of certain student loans. Student loan cancellation due to meeting certain work requirements, cancellation loans after December 2020 or before January 26, student loan repayment assistance programs, right? All this stuff, this is like the meat and potatoes of where you find all this stuff at. Like if you want to know how to, what these companies need to send you all the time, it can all be found in here. Foreclosure repossessions, right? How do I get repos off my profile? Repos are found the same way bankruptcies are found because they're all tied to your social. And we already talked about how you can find that on Pacer, right? But here, according to the IRS, are ways that you can also, or what these companies are supposed to do for repossessions, right? So there's a worksheet that you need to receive, which people don't receive. You also need a 1099-C form, a 1099-A, and a 1099-C, and they give you examples. All right. In 2020, Lily paid $200,000 for her home. She made a $15 down payment, borrowing the rest of $18,500. This is illegal. Can't mix a cash and credit transaction. You can get that $15K back, Lily. From a bank, Lily is personally liable for the mortgage loan, and the house secures the loan. In 2021, the bank foreclosed on the mortgage because Lily stopped making payments. When the bank foreclosed the mortgage, balance due was $180. The FMV of the house was $170, fair market value, guys. And Lily's adjusted basis was $175,000 due to the casualty loss she had deducted. At the time of foreclosure, the bank forgave $2,000 of the $10,000 in debt and access to the FMV. She remained personally liable for $8,000 balance. In this case, Lily has ordinary income from cancellation of debt in the amount of $2,000. Right? Again, this is income. So these companies should not be putting this stuff on your report. $2,000 income from the cancellation of debt is figured by subtracting. Yeah, we get that. Difference between the total outstanding balance immediately before transfer of property and amount which the person remains liable for after the transfer. She is able to exclude $2,000 and cancel debt from her income under the qualified principal residence indebtedness rule discussed earlier. Lily must also determine her gain or loss from the foreclosure. In this case, the amount that she realizes is $170. This is smaller of $172. Lily figures her gain or loss on the foreclosure, comparing $170 amount realized with $75 adjusted basis. She has a $5,000 non-deductible loss. Right. So this just gives you different examples of ways that this stuff's supposed to play out. But this stuff comes off. There's IRS procedures that these companies need to follow. And a lot of times they don't follow them because people don't know that they need to follow them. All right. So study this, review it. Another thing is we can actually can also send in our letters 15 USC 1692B. Right? False or missing representations. A debt collector may not use any false, deceptive, missing representation or means of connection with any debt without limiting general application of foregoing. The following conduct is a violation of this section. Now, I need to also stress what the definition of a debt is federally. The term debt means any obligation or alleged obligation. Any obligation or alleged obligation. Okay. Of a consumer to pay money arising out of a transaction in which the money, property, insurance, or services, which are the subject of the transaction, are primarily for personal, family, or household purposes, whether or not such obligation is reduced to judgment. This part is key. So until you get your own business and LLC, put everything in your business name. If the subject of the transaction is for personal, primary, or household purposes, right, that makes it accessible here. All right. Once you have a business, then the primary purpose of the transaction is not for personal, family, or household purposes. So this term changes definitions. But it's alleged obligation. So we never admit that a debt is ours. We always use alleged. All right. Now, right here. Okay. Representation or implication that non-payment of any debt will result in the arrest or imprisonment of any person or the seizure, garnishment, attachment, or sale of any property or wages of any person, unless such action is lawful and the debt collector or creditor intends to take such action. Now, debt collector, we already know the definition of this is, right? You know what the definition is of that. Creditor. Term creditor means any person who offers or extends credit creating a debt or to whom a debt is owed. But such term does not include any person to the extent that he receives an assignment or transfer of a debt in default solely for the purpose of facilitating collection of such debt for another. Repossession is typically done by a collection company. Collection companies aren't creditors. So when they assign something to these companies, and the only thing they're doing is trying to collect, false and misleading representation, my people. These are just basic definitions. These are federal definitions. Says so right here. Does not include any person to the extent he receives an assignment or transfer. So if the original creditor is not the one trying to take this action, it's not lawful. Gotta know your rights. Gotta know your rights. This is also a fun one. Help the client out with this one in a lawsuit. False representation or application that any individual is an attorney or that any communications from an attorney. No attorneys can talk to you about a debt. It's clear as day right here. It's a violation of this statute. It is what it is. Don't have to like it. Got some lawyers out there that blocked me from certain groups because I was trying to educate people. It's going to come out eventually. But that's it. That's repossessions, charge offs. I'll drop a template, I guess, in the course files for you guys. But study that publication 4681 and study 15 USC 1692E, and you guys are good to go. It's your boy, Credit Union Captain.